Okay. Assalamualaikum and a very warm good morning to everyone in the room. Welcome to Gadis Masa Kini, a forum where we bring together some of today's brightest young women to discuss real legal issues that matter in our everyday lives. Today, we'll be diving into a question that touches on family law, specifically the grounds for divorce and the rights of a married woman under the LRA. It's a topic that's so close to home and one that every woman deserves to understand. Before we get into it, allow me to introduce the four remarkable women who will be sharing their insights with us today. First, please welcome Miss Najah, a law undergraduate and moot court competitor who has proven herself time and time again in the courtroom settings. Next, we have Miss Alicia, a Dean's Lee student and also a legal research enthusiast with a sharp eye for detail and a passion for justice. Our third speaker, we have Miss KHALISHAH, a family law advocate and a student legal aid volunteer who has dedicated her time to help those in need in navigating the legal system. And finally, Miss DANIA, an aspiring litigation lawyer and public speaking champion who is no stranger to making a strong case. Ladies, it's truly wonderful to have all of you here. I'm sure we're all in for a very insightful session today. Before we begin our discussion, let's first watch a video that has recently gone viral on social media. As you watch the video, consider this question. Based on the facts presented, what are possible remedies? What are the possible grounds available to Kajal to petition for divorce under the LRA? And which of those grounds are most likely to succeed?
You never listen to me!
I have evidence of the abuse.
I will marry you soon.
Now that we've watched the video, I would like to hear any summary of the cases by any one of our lovely panelists.
May I?
Yes, thank you so much, Miss Alicia.
The video tells the story of Kajal and Shiva, a couple who have been married for 20 years and have 4 children together. Over time, their marriage became increasingly strained as Shiva allegedly subjected Kajal and their children to physical violence as well as emotional and verbal abuse. Fearing for their safety, Kajal lodged a police report. The couple have been living separately for the past 2 years. The situation became even more complicated when Jiva met a model named Jenny and allegedly promised to marry her. Following this promise, Jenny relocated from Singapore to Kuala Lumpur to be closer to him.
Oh, I see. I believe the audiences are very clear on the summarization of the cases. Back to the question. For our first panelist, Ms. Najah, let's focus specifically on the issue of adultery. We know that Jiva has developed a relationship with another woman, Jenny. Let's begin with the basics. Under the Malaysian law, what must a person prove before obtaining a divorce on the ground of adultery?
Okay, so under Section 54, Subsection 1A of the LRA, the petitioner must prove two things. First, that the respondent has committed adultery. Second, that because of the adultery, the petitioner finds it intolerable to continue living with the respondent. Both elements must be established before the court will grant a divorce on this ground. The petitioner must also show that the adultery caused him or her to find continued rehabilitation intolerable. This principle was established in Roper and Roper and has been applied by Malaysian courts. Therefore, there must be a direct connection between the adultery and the petitioner's inability to continue the marriage.
Oh, that sounds like quite a strict requirement. How does the court determine whether adultery has actually occurred?
The court requires strong evidence. In Chu Yi Fong and Oi Sing Kiat, the court held that adultery must be proved beyond reasonable doubt. Mere suspicion, rumors, or assumptions are insufficient. The petitioner must produce convincing evidence that adultery has in fact taken place. So in that case, the petitioner alleged that the respondent had committed adultery. However, the court found that the allegation was not sufficiently proven. As a result, the adultery ground failed. Eventually, the marriage was dissolved based on another ground, namely 2 years separation with consent.
Apart from proving adultery, you mentioned that the petitioner must also show that the adultery caused the breakdown of the marriage. Why is this important?
This is important because the law requires a causal connection between the adultery and the petitioner's inability to continue the marriage. A good example is in the case of Benny Punama and John Andrew Risco. In that case, the husband admitted that he was involved with another woman and was living with her. However, the court found that the marriage had already broken down before the affair began. The husband and wife had already drifted apart and no longer maintained a normal marital relationship. The wife was also aware of the affair for several years and was willing to forgive her husband if he returned to her. Therefore, the court held that she had condoned the adultery and failed to prove that the adultery caused the breakdown of the marriage. As a result, her petition based on adultery was dismissed. Next. In the case of Dr. Gomal Kaur and Dr. Teh Siong Peng, the wife successfully proved that her husband had committed adultery. Although the husband denied the allegation, the court accepted the wife's evidence and found that adultery had been established. Since the required elements were proven, the court granted the divorce.
After watching the video just now, many of us may be asking the same question. Can Kajal actually obtain a divorce on the ground of adultery? Based on the law and the facts presented, what is your view?
Kajal may face difficulties in doing so. In order to apply for divorce on the ground of adultery, the principle under the case of robber and robber must be followed. Kajal must prove that Jiva has committed adultery and the action caused her to find continued cohabitation intolerable. Although there is evidence that Jiva has developed a relationship with Jenny and has even promised to marry her, there is no evidence that they have engaged in a sexual relationship. Under the principle established in Chong Yi Fong and Oi Sing Chat, adultery must be proven with sufficient evidence. Therefore, a promise to marry another woman by itself does not amount to proof of adultery. Okay, next. Even if Kajal can prove adultery, she must show that the adultery is the cause of the breakdown of the marriage and made it intolerable for her to continue living with Jiva. As in the case of Benny Purnama and John Andrew Gisco, if the marriage had already broken down before the adultery occurred, the court may find that the adultery was not the cause of the breakdown. Here, Kajal and Jiva have been living separately for 2 years. Jiva only have relationship with Jenny recently, so it can be inferred that the marriage appears to have broken down mainly due to Jiva's physical, emotional, and verbal abuse, not because of the relationship between Jiva and Jenny. Therefore, Kajal may face difficulty in proving that Jiva's affair with Jenny was the reason she could no longer live with him. Unlike the case of Dr. Gumal Kaur and Dr. Teh Siong Pong, external facts do not provide clear proof of adultery. So, Kajal's claim based on adultery may not succeed unless stronger evidence of a sexual relationship between Jiva and Jenny can be produced.
Oh, so what is your conclusion regarding Kajal's chances of success?
Based on the available facts, Kajal is unlikely to succeed in a divorce petition based on adultery under Section 54(1)(a) of the LRA. There is insufficient evidence to prove adultery, and the breakdown of the marriage appears to have resulted from Jiva's abusive conduct and the parties' separation rather than alleged relationship beginning. Therefore, the adultery ground is unlikely to be established.
I see. Thank you so much, Miss Naja. That was a thorough discussion on Section 54, Section 1, Para A. Now, we move on to our second round, and I would like to invite Miss Arisha to walk us through Section 54, Section 1, Para B of the LRA. Miss Arisha, the floor is yours.
Thank you. I will now be addressing the second ground for divorce, which is Section 54, Subsection 1, Subpara B of LRA. Under this section, it provides that a divorce may be granted where the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with them. The courts have developed several approaches to assess unreasonable behavior, including the reasonable person test, the behavior test, and the breach of the marital obligation test. According to the case of Livingstone and Livingstone, the court applied the reasonable person test. The husband had repeatedly subjected his wife to verbal abuse and criticism, causing emotional harm. The court considered whether a reasonable or right-thinking person would be expect the petitioner to continue living in such circumstances. It held that no reasonable person would expect continued cohabitation, and therefore the divorce was granted. In the case of Ash and Ash, the court applied the behavior test by examining the overall conduct of the husband within the marriage. The husband had engaged in physical violence and habitual drunkenness. The court assessed the totality of the circumstances rather than isolate incidents and conclude that the behavior made it unreasonable to expect the wife to continue living with him. As such, the petition for divorce was allowed. By contrast, in Pheasant and Pheasant, the court applied the breach of marital obligation test. The husband alleged that his wife was emotionally distant and lacked affection. However, the court held that such dissatisfaction did not amount to a serious breach of marital duties. It emphasized that not every unhappiness in marriage justifies divorce, and that the conduct must reach a significant threshold before it can be considered unreasonable behavior.
So we have three distinct tests from three different cases, and each drawing a line on what qualifies as unreasonable behavior. Now, let's see how all of this applies to Kajal's situation. Please continue, Ms. Anisha.
Thank you. Applying Section 54, Subsection 1, Subpara B to Kajal's situation, there are strong grounds to establish that Jiva has behaved in such a way that Kajal cannot reasonably be expected to live with him, as evidenced by multiple forms of serious misconduct throughout the marriage. First, as per the reasonable person test in Livingstone and Livingstone, Jiva has subjected Kajal to repeated emotional and verbal abuse, including doing so in public. No right-thinking person would expect Kajal, a woman who has endured years of such degrading treatment, to continue cohabiting with Jiva. The public nature of the verbal humiliation further aggravates the harm, as it stripped Kajal of her dignity, not merely within the private sphere of home, but in the eyes of the broader community. A reasonable person would unquestionably find it unreasonable to expect Kajal to remain in such a marriage.
And the public humiliation really does add another layer to it. What about the behavior test?
Exactly. For the behavior test, as in Ash and Ash, Jiva's conduct encompass both physical violence against Kajal and their children, as well as persistent emotional and verbal abuse. Jiva's patterns of physical and emotional misconduct sustained over a significant periods of the marriage and serious enough to compel Kajal to make a police report and eventually live separately, collectively establish unreasonable behavior of a grave nature. The combinations of domestic violence and public humiliation, viewed in their totality, clearly satisfies this test.
So it's really the combination of everything together that makes it so compelling. And what about the marital obligation test?
Yes, lastly, applying the marital obligation test from Pheasants and Pheasants, Kajal's situation involved objectively serious and harmful conduct. Jiva's physical violence, extending even to the children, and his sustained verbal and emotional abuse are far removed from mere marital dissatisfaction. This act constitutes a grave breach of the fundamental obligations of marriage, while exceeding the threshold required under Pheasants. Accordingly, this is not a case where the court would dismiss the petition on the basis that the conduct is insufficiently serious.
That is very well laid out. So, all three tests are satisfied on these facts. Any final remarks before we move on?
Yes. Just to conclude, Kajal has a very strong grounds to petition for divorce under Section 54, Subsection 1, Subpara B of the Law Reform Marriage and Divorce Act 1976. The physical violence, emotional abuse, verbal humiliation, and the circumstances that compelled her to seek police protection collectively demonstrate that Jiva has behaved in such a way that no reasonable person would expect Kajal to continue living with him.
Thank you so much, Miss Alicia. Two very strong grounds established so far. We'll now pass it on to our third speaker, Miss KHALISHAH, who will be discussing on the ground of living apart as we knew from the facts that Kajal and Jiva have been living separately. Let's begin with the facts. Under Malaysian law, what must a person prove before obtaining a divorce on this ground?
Thank you, Ms. Naili, for inviting me. So, under Section 54, Subsection 1, Paragraph D of the LRA, a divorce may be granted where the parties have lived apart continuously for 2 years and the petitioner believes the marriage has irretrievably broken down. This is no fault ground as it does not require proof of wrongdoing, although the court may still consider the possibility of reconciliation. A clear example of this is the case of Saravanan, anak lelaki A. Narayanasamy, and Minachi, anak perempuan Subramania. In that case, the husband filed a unilateral divorce petition because the couple began living in a separate houses from 26 December 1986 onwards. And then the High Court allowed the husband petition and granted a decree nisi for the dissolution of the marriage because they satisfied the physical requirement of living apart.
That seems straightforward when people are physically residing in different locations. But what happens if the lines are blurred? Say, if a spouse sleeps elsewhere but still acts as part of a household during the day, how strictly do the courts define living apart?
Okay, so the court looked closely at the reality of the couple daily life and this is as well illustrated in the case of Leong Kwek Kyong and Lee Ying Kwan. In this case, the husband, the petitioner, sought a unilateral divorce from his wife, a respondent, on the ground that the marriage had irretrievably broken down. He relied on the statutory fact that they had lived apart for a continuous period of 4 years, and despite moving his sleeping quarters to his parents' house, the husband returned to the matrimonial home almost every single day during his waking hours, and he also ate dinners with the family, had his clothes washed at the home by the wife, and maintained the normal family outings. Crucially, he also continued to engage in a regular sexual relationship with the wife, and as a result of the continued intimacy, the wife became pregnant and gave birth to a child 2 years into their alleged separation. And then, therefore, the court found that the parties had not truly lived apart as required by law and dismissed the petition. Merely choosing not to sleep under the same roof did not suffice when the husband's entire daytime conduct, domestic alliance, and physical intimacy pointed directly to the continuation of a shared marital life.
That makes complete sense. The law requires an actual breakdown of the marital bond, not just a change of sleeping quarters. So, how do we apply these strict legal parameters to Kajal's specific situation?
Applying the principle under Section 54, Section 1, Paragraph D, Kajal satisfied both the statutory threshold because he and Jiva had been living separately for 2 years, and due to their hostile circumstances, it is clear that Kajal believes the marriage has irretrievably broken down as there is a clear intention from her that to end the marital relationship. By lodging a formal police report to escape from Jiva's severe physical violence and public emotional abuse, it is evident that she wanted to get away from Jiva for her protection and the 4 children.
How do the cases we discussed earlier reinforce her legal position if her husband decides to dispute the divorce?
Following the principle in the case of Saravanan and Minachi, the 2-year split sparked by severe marital discord is enough to show that marriage has been severed. In Kajal's case, the separation is backed by extreme abuse, and the fact that Jiva has already moved in with a new partner, Jenny, proves that both sides has already entirely moved on, making the reconciliation impossible. And in this situation contradict with the case of Leong Kwek Kong and Lee Ying Kwan, as despite of earning massive salary of 15,000 ringgit, he contributes nothing to the matrimonial home and leaving Kajal to pay for the loan even via deductions from her own salary. And there is no proof that Jiva has committed to his responsibility as a father and husband. And furthermore, his continuous action of mentally and physically abusing Kajal and their children prove that he did not abandon he had abandoned his parental responsibility. And thus, Kajal has strong evidence to terminate the marital bonds through Section 54, Subsection 1, Paragraph D from the 2-year separation. And thus, we come into the conclusion that Kajal may petition for divorce against Jiva under the Law Reform Act on the ground that the marriage has irretrievably broken down pursuant to Section 53, Section 1 on the ground of Section 54, Section 1B and D of the Act.
That was incredibly insightful, Miss Kalisha. You have clearly shown us how the courts look beyond a simple change of address to evaluate the true reality of a breakdown under Section 54/1 parody. Thank you for breaking down Kaja's position so detailed for us. Now that we have a solid understanding of how living apart applies to Kaja's case, we need to examine another critical layer of this marital dispute. To take us through the next legal issue, please welcome our next presenter, Ms. Dania, who will discuss regarding the jointly acquired properties during the subsistence of a marriage. As they face a divorce, the massive question before us is what are Kajal's rights to claim their jointly acquired property under Section 76 of the Law Reform Marriage and Divorce Act 1976. Firstly, let's break down the assets. A matrimonial home, two co-owned shop houses, and Jiva's 500,000 EPF savings. So, Ms. Dania, is there any possibilities for Kajal to claim any properties after her divorce?
Thank you, Ms. Niley. To start with the law, Section 76 of the Law Reform Act gives the court the power to order the division of assets when a marriage is dissolved. Under Section 76, subsection 5, matrimonial assets are not just things bought together. They can even include assets owned before the marriage by one party if they were improved during the marriage by the other party or through joint efforts. Now, when distributing these properties, the court doesn't just guess. Section 76, subsection 2 forces the court to look at 5 critical factors, which are the extent of direct financial contribution, which is in forms of money or property, the extent of indirect contributions made to the welfare of the family, any debts contracted by either party for their joint benefit, the needs of minor children, and lastly, the duration of the marriage, which in this case is a length of 20 years.
Excellent. So, how do we apply these 5 factors to Kajal's specific direct and indirect contributions?
Firstly, let's look at the matrimonial home. Under Section 76, subsection 2, paragraph A, Kajal has a massive direct contribution because she took out the loan and has her monthly salary automatically deducted to service the installments. Regarding Section 76, subsection 2, paragraph B, the facts are silent on Jiva's indirect contribution to the home. But we do know that under Section 76, subsection 2, paragraph C, the welfare of their minor children must be prioritized. Since they have minor children among their 4 kids, those minors need stability and should continue residing in that matrimonial home.
That makes complete sense. Now, is there any case law further supporting this matter?
Of course there is, Miss Niley. Case law is incredibly favorable to Kajal here. First, if we look at the landmark case of Ching Seng-Woh and Lim Shu-Lin, the court held that matrimonial assets include everything put into the matrimonial home by either spouse to be used together by them and their children. Furthermore, the case of Wong Kim Fong and Tiao Ah Kau reminds us that share capital assets are also matrimonial assets, divided based on the extent of each party's contribution. But what about Jiva's 500,000 ringgit EPF savings? Jiva might argue that is his personal retirement fund. However, the court in the case of Parkunan anak lelaki Aculingam and Kalai Yarashi anak perempuan Pariasami firmly held that EPF money accumulated during a marriage is a matrimonial asset because it is required during the marriage framework. Therefore, Kajal absolutely has a right to share of that 500,000 ringgit of EPF money savings.
That's a huge win for Kajal. But how exactly will a judge split the house and the 2 shop houses in reality? Do you have a precedent for this specific type of dispute?
Yeah, actually we do. The facts in the case of Pranuka anak perempuan Munyanti or Ramakrishnan and Jiva anak lelaki Kalia Paruma, it was held that the wife was also a teacher who paid the monthly loan installments for the matrimonial home. The High Court ordered a 40-40 and 20 split, which means that 40% to the wife for her direct contribution, 40% to the husband for his indirect contribution, and the remaining 20% to be held on trust for their children. Crucially, because the wife was a teacher paying a housing loan, The court gave her a reasonable timeline of 12 months to buy out her ex-husband's share. Applying the case of Renuka to our current situation of Kajal, she should receive a higher share of the home due to her direct salary deductions. Jiva will get a share matching his indirect family contributions, and a portion should be held in trust for their 4 children until they reach adulthood. As a teacher, Kajal should also be granted a generous grace period to pay off Jiva's portion.
And what about the two shop houses from the Renuka precedent?
Referring to the case of Renuka, since there were two shop houses, the court cut straight through the complexity and distributed them evenly, giving one shop house to the wife and one to the husband. Following this, Kajal and Jiva should walk away owning one shop house each.
Fascinating. Let's wrap this up. What is our ultimate legal conclusion for Kajal?
So basically, in conclusion, Kajal has right to claim for their jointly acquired properties, including the matrimonial home, the PF money, and also the shop house, under Section 76 of the Law Reform Act, to claim her equitable share in all the jointly acquired properties. She is legally entitled to a dominant stake in the matrimonial home, and even 50% split of the two shop houses, and a rightful share of Jiva's 500,000 ringgit EPF savings. The law completely protects her economic contribution to this 20-year marriage.
Thank you so much, Miss Dania. Thank you to our brilliant panelists, and thank you to our audience for your time and attention. This concludes our forum, and have a wonderful day. Bye-bye.